We're with David Shapiro. David is a DUI lawyer in San Diego, California, and he's going to agree to answer an online question specifically related to if you can be found guilty for DUI without a breath test showing you're over the legal limit. David, let's go into the question that was asked. Oops. Apologize. Samantha says, I was pulled over at a San Diego DUI checkpoint. I was given a breath test and a field sobriety test. The officer said I failed both, and then I was arrested for DUI. Something happened with the breath test results, and they can't be used. Can I still be convicted of a drunk driving?
Well, a couple of things. I would want to know what breath test something happened to, because generally speaking, Samantha, when you're arrested for a DUI or when you're under investigation for a DUI, you will be asked to do a voluntary field sobriety test. You don't need to do them, but more often than not, people do. One of those field sobriety tests is something known as the PAS device. It's a PAS. It's an acronym for Preliminary Alcohol Screening Device. That's a handheld breathalyzer, which results cannot be used scientifically to determine your blood alcohol level in court, but is generally used as another tool that law enforcement has to determine whether or not you're close to, at, or above the legal limit of 0.08 or higher at the time driving. Okay, so that's one thing. So if the issue was with the preliminary alcohol screening device test, then that wouldn't be allowed to maybe be introduced in court. Although then the main issue would be after you're arrested, the chemical test, whether breath or blood, assuming it was a breath test, an intoxilizer test here, if that were to be suppressed and they would not have anything else to use as a chemical test after your arrest, then there would be a big time problem as far as being able to prove that you were under the influence of alcohol, and particularly that you were 0.08 or higher at the time driving. If your question is focused more on if the breath test comes back at results below a 0.08, which I think was the first part of the question, I've seen, and I would not be surprised if the prosecution, whether it's a district attorney or city attorney, if the case is prosecuted downtown San Diego as a misdemeanor, I would not be surprised if they try and move forward, even if you might have a breath test result below a 0.08. And they can do that pretty much for two reasons. One is DUI laws are written basically two different vehicle code sections or subdivisions of the same vehicle code section that you're going to be charged with. There's 23152 A as an apple and B as in boy of the vehicle code. The B as in boy count, they have to prove that you're 0.08 or higher at the time driving. So if they don't have that, well, that's a problem. If they don't have any chemical tests, it's certainly a problem. The A count, they would need to prove that you were under the influence of alcohol at the time driving. Doesn't necessarily need to prove the blood alcohol level, but they need to show there was some alcohol in your system and that alcohol affected your ability to safely operate a motor vehicle. The second issue is, even with the B count, if your blood alcohol level was say a 0.07 or a 0.06 or even a 0.05 at the time of the chemical test, well, that's great. And that may give you a very well give you a really good defense to the 0.08 or higher charge. But remember what I said a little bit earlier, the law says that it has to be 0.08 or higher at the time you were actually driving. So an argument could be made depending on your drinking pattern, like your first drink, your last drink, all those things that the police ask you, and that's important. And it's important not even to answer them if you have that, knowledge going into the situation, because you don't want to establish a drinking pattern. Because if you say, hey, my last drink was 4 hours ago, and you come back at a chemical test at a 0.05, yeah, so what? It wasn't right when you were driving, but clearly your blood alcohol level was going down. So an expert could look at that result and say, okay, a 0.05, 45 minutes after driving, they hadn't had a drink on their own admissions in 3 hours. I think this person may be a 0.08, 0.07 at or near that level at the time they actually drove. So just because your level may be below a 0.08 doesn't mean you're out of the woods on both DUI counts. If there's no level at all to work with, you have a real strong argument in the event the prosecution wants to proceed without that key evidence.
Excellent. Well, if you have any other questions for David, just post them in the comments section below. Thanks for the answer.
Yeah, my pleasure. I could also be reached at 619-295-3555.